Good morning, everyone. Thank you for attending the Understanding the ASEAN Comprehensive Investment Agreement and what it means to business webinar. We are very glad to present to you our first webinar series. Today, we have 3 speakers from the government and private sector presenting. For the first presentation, sharing of ASEAN Comprehensive Investment Agreement, we have Mr. Eric Pei, Senior Assistant Director for Ministry of Trade and Industry, and Ms. Hongjuan Zhang, Associate International Arbitration from Allen and Overy, Singapore. Next up, we have Mr. Francis Xavier, Regional Head from Raja and Tan, for a sharing on investment pitfalls in ASEAN. We'll end up with the Q&A session moderated by Mr. Jason Lee, Director for International Policy and Engagement from Singapore Business Federation. We welcome all questions to be posted on the Q&A box at the bottom of your screen. Without further ado, I'd like to welcome Mr. Eric Pei and Ms. Hongjuan for their presentations.
Hi, good morning, everyone. Thank you for signing up for this webinar on the ASEAN Comprehensive Investment Agreement today. My name is Eric Pei and I'm from the Ministry of Trade and Industry. Just a little bit of background about myself. I'm a trade negotiator from the ASEAN division and I represent Singapore in our FTA negotiations in ASEAN as well as with ASEAN's dialogue partners. Before I start, I would like to thank the Singapore Business Federation for organizing this webinar, which would be very helpful to help our businesses in understanding the benefits of Singapore's FTAs, more specifically the ASEAN Comprehensive Investment Agreement, or what we call the ACIA, in today's webinar. I think for the most part, I think most people are generally quite aware of the benefits of the trade in goods or the tariff reduction side of our FTAs, but most people are less aware of the trade in services or investment side of our FTAs and the benefits which these chapters of our FTAs can bring to Singapore and Singaporeans. So I hope that in today's webinar, Singaporeans and Singapore businesses can gain a better understanding of the benefits of the ASEAN Comprehensive Investment Agreement and walk away with some learning points on how you can use the ACIA in your businesses. Before I start, maybe just to give a little bit of historical context on the ACIA. The ASEAN Comprehensive Investment Agreement was signed in 2009 and it entered into force in 2012. Thereafter, 4 protocols were signed to amend the ACIA and keep it up to date with modern FTA provisions. The first protocol was signed in 2014, and this was introduced to set out the procedures which ASEAN member states can go about to amend their schedules of reservations. I'll go more into the schedules of reservations later in my presentation. Subsequently, the second protocol was signed in the first half of 2017, and this is to allow for the recognition of permanent residents on a reciprocal basis. Once again, I'll go more into that in greater detail later on. And then in the second half of 2017, the third protocol was signed, and this removed paragraph 8 of Thailand's ACIA reservation list, which excluded the ACIA's application to Thailand-based investments which are owned by non-parties to the ACIA. Lastly, the fourth protocol was then signed in 2019, and this introduces more prohibition of performance requirements obligations into the ACIA, in line with modern FTA practice. So now, before we even continue on what are the benefits of the ACIA, you may wish to know about the types of investment that is actually covered by the ACIA and what qualifies as an investment under the ACIA. So if you were to look at the definition section of the ACIA, you realize that there is an open-ended definition for investment in the text. And this is deliberately kept broad so that it includes as many types of investments as possible. The key characteristics that we look for in an investment is whether there is a commitment of capital with the expectation of gain or profit or the assumption of risk. So for example, if you look at the definitions, there is a long list of examples of what constitutes an investment, from movable and immovable property and other property rights, shares, stocks, bonds, and debentures, claims to money or to any contractual performance, intellectual property rights, contractual rights, business concessions even. So basically, anything that has the general characteristics of investment is more likely than not to qualify as an investment that is under the coverage of the ACIA. Now, in terms of the geographical coverage of the ACIA covers any investment that is made in the territory of any other ASEAN member states. For those of you that are not aware of who the ASEAN member states are, this includes the 10 nations of Brunei, Cambodia, Indonesia, Laos, Myanmar, Malaysia, Philippines, Thailand, and Vietnam. In terms of who can enjoy the benefits of the ACIA, the definition of an investor covers the natural person of a member state as well as a juridical person of a member state. Now, for the natural person of a member state, this includes two categories of people. The first is that of Singapore citizens or citizens of ASEAN member states, and the second is that of permanent residents, provided that the investment destination also recognizes the concept of permanent residence. This is because not all ASEAN member states actually have the concept of permanent residence, so they may not necessarily accord the same kind of rights to the permanent residents of other ASEAN member states. So within ASEAN itself, only 3 ASEAN member states recognize the permanent residence, and that is Singapore, Malaysia, and Brunei. Now, as for juridical persons of member states, this generally refers to companies that is set up or incorporated in the member state. So for example, a Singapore company would be covered by the ambits of the ACIA. So there are 4 key substantive benefits under the ACIA, the first of which is the national treatment obligation. So what the national treatment obligation basically means is that each member state must treat the investor of any other member state the same as how it treats its own domestic investors. So for example, if I do not have a requirement that domestic investors must put up a deposit before I can start a business, I cannot have such requirement for a foreign investor because I must ensure that there is a parity of treatment between foreign investors and domestic investors. So if you're investing in a region or you have a branch company in one of the ASEAN member states and you spot a law or regulation that does not discriminate or that discriminates or provide for a different treatment for a foreign investor, there is a possibility that this is in contravention of the ASEAN Comprehensive Investment Agreement commitments. However, that said, this obligation is not an unqualified one, and there are exceptions to this obligation. Countries and parties to the ASEAN Comprehensive Investment Agreement are allowed to list down exceptions to this obligation in their schedules of reservations. But I'll share more about the schedules of reservations later on and how businesses such as yourself can read the schedules of reservations. The good thing about the ASEAN Comprehensive Investment Agreement's provision on national treatment is that it also includes the pre-establishment investment. So what pre-establishment investment means is that you do not actually need to have already made an investment in the ASEAN member state to be able to avail of the rights of national treatment. You can avail of the right of national treatment even when you are just making steps towards making an investment in an ASEAN member state. Of course, this is not entirely unqualified and you do need to have taken concrete steps towards making an investment. So this includes, for example, procuring lawyers to do due diligence for your investment or making some kind of pre-investment kind of research into the area to be able to qualify as pre-establishment investment. This is not always the case in all of our FTAs across ASEAN. So for example, if you look at the RCEP, which was recently, or rather it was entered into force recently, earlier this year, you can see that the national treatment obligation there does not include the admission of investment. So if you look at the second half of this paragraph on your screen, it says this covers investors with respect to the admission, establishment, acquisition, expansion, management, conduct, operation, and sale or other disposition of investments in its territories. The RCEP does not actually have admission of investment in it. So the ACIA is actually a superior investment agreement in that respect. Now, the second obligation, or rather the second substantive benefit under the ACIA, is the commonly known principle of MFN, or what we call the most favored nation treatment. What MFN means is that each ASEAN member state must treat investors of another member state the same as it treats other investors from other non-parties. So there are two elements involved here. One is that within ASEAN itself, you must treat the investors of each ASEAN member states the same as any other member state. So within the agreement, within the parties of the agreement, you cannot discriminate and give a better treatment to, say, Malaysia or to Thailand over like Indonesia and Singapore. There must be uniform treatment throughout the entire ASEAN region. The second element is that you must treat investors of each ASEAN member state the same as any other non-party to the FTA. And this is a very broad commitment because it essentially covers every country in the world, and hence the name most favored nation treatment. This is actually quite a huge commitment because it means that even after signing the ACIA, Singapore cannot enter into another FTA that provides better treatment to their investors than that of ASEAN investors. Or at least if you do, you must now accord the same level of treatment given in that FTA to the ASEAN investors. This is a wide-ranging commitment, and it really just goes to show the closeness of Singapore's relationship with our ASEAN brethren. In fact, in all of Singapore's other FTAs, if you looked at the schedules of reservations, Singapore's schedules of reservation will always have a reservation that says that Singapore will reserve the best treatment to our ASEAN neighbors, at least in the investment agreement. When we signed the ACIA back in 2009, there was also an agreement that no ASEAN member state shall be allowed to make a reservation or exception to this principle in their schedules of reservation. So this commitment is really one of the few unqualified ones in the ACIA. Now, for the third substantive obligation under the ACIA, this is that of the prohibition of performance requirements, or what we call PPR. What the PPR obligation does is that it prohibits parties from attaching certain conditions in exchange to allowing the investments to be made in their country. So the relevant provision reads in the ACIA that there are 6 key requirements that ASEAN member states cannot have in exchange for making a reservation, in exchange for making an investment in the country. So the first one is that countries cannot impose an export quota in exchange for an investor setting up a manufacturing plant or something like that in the ASEAN member state. So for example, if you set up a sneaker factory in like Vietnam, you cannot dictate that the factory must export like 60% of its output to other countries. The second is that of domestic content requirement. This means that you cannot impose requirements for the foreign investor to use local inputs for the production of its products. The third is that of you cannot have a requirement to purchase or accord a preference to domestic inputs. So this is similar to the second requirement of domestic content requirement. This means that you cannot require the foreign investor to have a certain preference towards using either domestic workers or domestic kind of raw materials. So the foreign investor may choose wherever it likes to import its raw materials from. The fourth requirement is that of you cannot have export-import kind of ratio dictated for the foreign investor. So you cannot say that to maintain your foreign currency reserves, for every import that you have, for every dollar import that you have, you must export 50 cents or 80 cents of your produce and not sell it locally. So you cannot have that requirement. The fifth requirement is that of the restriction of sale of goods domestically. This case is more rare, but we still do see it in the past in some ASEAN member states prior to the ASEAN Comprehensive Investment Agreement. And that is, you cannot require the foreign investor to sell their goods exclusively to local people only. And the sixth and last PPR is similar to the fifth one. It's just that you cannot have a requirement that the foreign investor must supply exclusively to a specific region or to a specific country just to meet the contractual obligations of the state. So what this really seeks to do, this PPR obligation, is to make the investment environment for foreign investors as conducive as possible and to ensure a level playing field with domestic investors. Now, the fourth and last example, the last and fourth substantive benefit under the ACIA is that of senior management and board of directors. So what this means basically is that ASEAN member states cannot impose a requirement on the nationality of senior management. So for example, you cannot force a foreign company to hire locals in the position of like CEO or other C-suite positions or senior management positions in the local branch office. However, there's an exception to these, and ASEAN member states are allowed to impose nationality requirements for its board of directors. So depending on whether the board of directors is in an executive role or a non-executive role, this may affect whether you may actually have a nationality requirement for the director or the senior management of the company. But of course, this is also not an unqualified exception. This requirement is only allowed if it does not materially impair the ability of investors to exercise control over its investment. Once again, this is a reservable obligation. So if there are specific instances where you encounter such requirement in your investments into the region, this is more likely because it has been reserved against in the member state's schedule of reservation. So this actually brings me to the point of what exactly is this schedule of non-conforming measures. This schedule of non-conforming measures or reservations is basically an annex to the main FTA agreement that contains a list of exceptions to the obligations of national treatment, PPR, and SMBD, which I mentioned earlier. So for example, if Singapore has a law or regulation that does not comply with any of the obligation of national treatment, PPR, or SMBD, we would have to add this law or regulation to the schedule of non-conforming measures. Now you may ask, doesn't this schedule of non-conforming measure then defeat the purpose of having the FTA if parties are just allowed to carve out whatever law or regulation that they have that does not conform with the obligations of the FTA? Well, my answer to you to this is that it's not entirely true that it defeats the purpose of the FTA, because the purpose of the schedule of non-conforming measures is to allow for greater transparency to investors into the region so that they may go into their investments with eyes wide open and know the laws and regulations that they may have to comply to when they invest in the market. And secondly, the schedules of non-conforming measures that you see right now on ESG's website, or rather Enterprise Singapore's website, it's not something that the member state just put down and it was signed upon. we do negotiate with our counterparts on the substance of these schedules, and it is not a free-for-all for parties to list down whatever law or regulation that they have currently. If we see a law or regulation that is onerous or overtly discriminatory to our investors, we do have the opportunity to negotiate for the removal of these laws and regulations from the schedule of reservations. And also, this is a two-way street ultimately, and it also allows Singapore to list down our laws and regulations that are non-conforming to the FTA obligations. So it is not unqualified right for parties to be able to list down any kind of like exceptions that they would like to see to the FTA obligations. In terms of how to read the schedule of non-conforming measures, I've put an example of a schedule of non-conforming measure on this slide that you see here. So in general, you see entries for each of the exceptions that the countries have to the obligations. So if you look at this example on your screen, this is a non-conforming measure for the manufacture, sale, storage, transport, or possession of arms and explosives in Singapore. We have actually reserved against this manufacturing of arms and explosives because, as you know, this is a sensitive area. It involves national security. So this area is generally off limits for foreign investors. So in general, for each entry in the schedule of non-conforming measure, you see the sector which the non-conforming measure applies to, as well as the subsector that the reservation applies to. The level of government doesn't apply to us, but in countries like Malaysia, where there's a federal government and there's a state government, you can look at this row to see which level of government does this exception applies to. The type of obligation row tells you which of the obligation the member state wishes to carve out against for their exception. And the description of measure, as the name suggests, basically provides a brief explanation of what the exception that the member state seeks to achieve from this reservation. And of course, the source of measure states the statute, the laws, the regulation that applies to these exceptions. And you can look at the statute directly if you have any further questions or require further clarifications on what the exception pertains to. I hope that this provides an really brief and kind of general overall kind of explanation as to how to read the schedule of non-conforming measures, as well as the benefits that the AKIA brings to Singaporeans and Singapore businesses. Now I'll pass the time on to Hong Chuan, who will share more about the protective elements of the AKIA, as well as the investor state dispute settlement provisions in the ACIA. Thank you very much.
Thanks very much, Eric. Please give me a second as I share my screen. Sorry, Eric, I might have to trouble you to unshare your screen so that I can share my slides. Thank you. Sorry, just give me a second. Trying to fix the... Okay, so good morning, everyone. My name is Hong Chuan. I'm an associate at the International Arbitration Group of Allen & Overy's office in Singapore. And before I begin, I just wanted to thank the Singapore Business Federation for their kind invitation to speak and share on the AKIA. So this is my agenda for the presentation today. First, I'll touch on some additional gateway requirements that investors must meet on top of satisfying the investor and investment requirements, as Eric had touched on earlier in his presentation. Second, I'll go over some of the additional protections that AKIA offers investors in terms of what they might be to expect from a host state. And finally, I'll explain the benefits of investment arbitration and some practical considerations when one realizes that they might have a claim on their hands. So the reason why I call these gateway requirements is because if these are not met, then a claim will likely face significant difficulties getting past the gate. These issues should therefore be considered first before we look into the substantive protections. So the first gateway requirement is quite straightforward. In essence, a claim must be brought within 3 years, otherwise it becomes time barred. So the clock starts ticking from when the investor becomes aware or should reasonably have become aware of a breach by the host state. There must also be loss or damage. And this means that if you identify a breach by the host state, but it has not resulted in loss or damage to your investment, then there is no basis for a claim yet. The intent behind such a provision is to ensure that claims can be resolved when evidence is still available and fresh. As you might appreciate, over the course of a number of years, political appointees could change, officials in charge could move, and relevant records might not have been kept by the host state. The second gateway requirement is slightly more complicated. This is that the investor must not fall within the class of investors that are denied the benefits of the treaty. Sorry, give me a second as I move this. Sorry, I think this is okay. So the ACIA contains what is called a denial of benefits clause, and this is designed to deny the protections of the treaty to certain classes of investors, even if they satisfy the requirements of being an investor or having an investment as defined in the treaty. The underlying policy is to tackle what is called treaty shopping, whereby investors incorporate shell companies in the state to gain access to treaty protections, but without having substantive operations there. Now, this provision actually looks quite complex when you read the treaty itself, but essentially it sets out 4 categories of companies that are denied protection. And I'll explain the 2 most common scenarios in the interests of time. So for the purposes of illustration on the slides, the host state is listed as Philippines and the investing company's home state is Singapore. So the first category that's denied protection has 2 key features. First, it is a company incorporated in Singapore that invests in the Philippines, but is actually owned or controlled by a parent company that is incorporated in the US. In other words, the actual parent company controlling the investor is from a non-treaty state. And on top of that, this Singaporean company has no substantive business operations in Singapore. The term substantive business operations is not actually defined in the treaty, but tribunals have generally considered factors such as whether the entity has a physical presence in the state of incorporation, whether it conducts investment-related activities from its premises, whether it holds an active local bank account, and so on. The requirement's not that the operations have to be large scale, but that they have to be substantial. Sorry, that they have to be material. The second category that is denied protection is a company incorporated in Singapore that invests in the Philippines, but is actually owned or controlled by a parent company from the Philippines, and again has no substantive operations in Singapore. Here, the underlying objective is that the member states do not want to allow their own investors to use the treaty to sue their own home state if they have no substantive operations in the state whose nationality they're trying to make use of. Sorry. And now I'll move on to the substantive protections. As you can see here on the slide, there are various substantive protections provided by the ACIA, some of which were covered by Eric earlier. A measure or action by the host state will often give rise to breaches of multiple obligations. So what I'll do next is to go over the 3 most commonly litigated obligations. And at this point, I want to clarify that although I refer to the host state throughout this presentation for simplicity, I'm actually referring to a wide range of entities that could owe obligations to investors, such as ministries, operational agencies, the courts, and also state-owned enterprises in some situations. So the first is the obligation to accord fair and equitable treatment, or FET, to the investments of an investor. This is most frequently relied upon this is actually the clause that's most frequently relied upon by investors and often forms the basis for successful claims. And it can be applied to many different situations that might arise in the course of an investment. In a nutshell, it guarantees that the state will not act in an arbitrary, unreasonable, or discriminatory manner towards foreign investments. So to illustrate the point, I've set out here on the slide some examples of situations that might give rise to a violation of the FET obligation. The first type of situation is where legitimate expectations associated with the investment are breached. Host states often try to attract foreign investments in underdeveloped sectors or sectors requiring substantial capital outlay. And to do that, they often assure investors that there will be favorable regulatory frameworks that guarantee certain rates of returns, or that they will be entitled to licenses of a relatively long term. And this is quite common in sectors such as energy, infrastructure, and telecommunications. However, sometimes with a change of government or changes to socioeconomic circumstances, the host state might change its policies or try to alter the balance of benefits, such as by revoking licenses or imposing measures that affect the investor's expected rates of return. So one example of a case engaging legitimate expectations is that of Walter Bao and Thailand. So here the German investors were in a joint venture with the Thai government. And this JV obtained a concession to build and operate a toll highway in Thailand for 25 years. Issues arose because the investor's sole source of income was from the tolls, but its requests to increase the tolls at various junctures under the concession agreement were rejected. And the Thai government, acting through its directors on the joint venture, voted in favor of a toll reduction instead. On top of that, the Thai government also improved the surrounding toll-free roads, which caused a loss in the toll revenues for the toll highway. Thailand was found to have breached the investor's legitimate expectation to a reasonable rate of return, and the investor here was awarded 29 million euros in damages. The second type of situation is where the host state fails to treat the investment in a fair manner as a matter of procedure. So for many investors, they try to redress their rights, usually by first trying to challenge the actions of state agencies in the domestic courts of their host state. However, there have been cases where the local courts take an inordinately long time to decide on the matter or reach an outcome that is clearly not in line with the domestic laws. And here I wanted to highlight a threatened claim against Malaysia by a Thai investor. The investor in question bought several properties in Malaysia, but years later, someone fraudulently forged their signature to transfer the properties to a third party. The sale was challenged, but the Malaysian courts, despite acknowledging that documents were forged, had actually upheld the transfer. So the investor alleged that this breached FET, and the case was eventually settled by Malaysia paying an undisclosed sum in 2019. The third type of situation is where the host state treats the investment in an arbitrary or unreasonable manner. And that includes, for instance, taking measures for reasons other than what was set out in the explanation, or based on the personal preference of the host state's decision maker, or based on, for instance, some kind of prejudice against foreign investors. The second substantive obligation is that the host state shall not expropriate the investments of an investor without providing effective compensation. So there are two types of expropriation scenarios, which is direct expropriation and indirect expropriation. Direct expropriation is where an investment is nationalized or taken through formal transfer of title or outright seizure of the investment. And this is actually relatively rare these days. Indirect expropriation is the more likely situation. This is where an action or a series of related actions by a host state has a serious adverse effect on the investment, such as to reduce its value to virtually zero. Examples of potentially expropriatory measures could be if the host state revoked a necessary license for the investment or imposed high taxes on the investor's revenues. An example where expropriation was argued is that of Cemex in Indonesia. This was where the Mexican investor took a minority stake in a state-owned Indonesian cement firm and had an option that could be exercised to buy a majority stake by a certain time. However, the investor was not able to exercise the option effectively because of local opposition to a foreign takeover of the firm. Negotiations with the government to buy out the investor's minority share stalled, and the investor lodged a treaty claim on the basis of de facto expropriation. The claim itself was eventually settled by Indonesia for over 300 million USD. The third and last obligation I'm going to touch on is the obligation to accord the investment with what is called full protection and security, or what we often call FPS. AKIA, like most treaties, does not specify the kind of protection and security that's owed under this FPS obligation, but this is typically interpreted as covering physical protection and is engaged when there is, say, civil unrest in the host state and the investor's investment, such as a plant or their office, gets ransacked by military forces or rioters. A case in ASEAN where this obligation was engaged was a case brought by a Singapore investor. That's the case of Yongchi-U versus Myanmar. Here, the investor invested in a successful brewery in Myanmar, and one of the claims was that the armed agents of Myanmar had seized the brewery, which amounted to a breach of FPS. Unfortunately, this claim failed because of a gateway issue, but that being said, this type of fact pattern is certainly one that engages FPS. I should also highlight that FPS can sometimes be interpreted as also extending to guarantee the commercial and legal stability of the investment. Lastly, it should be noted that FPS in AKIA does not mean that the host state has to prevent the negative situations such as civil unrest from happening altogether, but that the host state must exercise reasonable care and take reasonable actions within its power to make sure that the investor is protected. And now I'll discuss the benefits of arbitration under AKIA and some practical considerations when bringing a claim. Before I move on to the next slide, I just wanted to quickly explain what is arbitration for those of you that may not be as familiar. This is a dispute resolution procedure whereby the dispute is submitted to one or more decision makers who make a binding decision on the dispute. It's different from going to court because the decision maker is not a judge and is usually a private legal practitioner. Arbitration is an alternative to going to court and is popular in commercial disputes because the outcome is usually faster. Parties get to have a say as to the choice of the decision maker, and they can pick someone with the relevant expertise to their type of dispute. There are usually 3 arbitrators on a panel. One of the parties will each get to choose one, and the 2 party appointed arbitrators will usually agree on the third one. So the AKIA allows investors to go to arbitration with the host state, or what is often called investment treaty arbitration. The key benefits are here in the slide, and I'll go over them quickly. First, it provides investors with the broad substantive protections that may not be available under the host state's own laws. Second, investors are given a direct right of action against the host state. What this means is that suing under the AKIA is possible even though there is no contractual relationship between the investor and the host state. And this is quite an important fallback insurance for investments. Third, even if there is a contract between the investor and the host state, a claim under the AKIA is not mutually exclusive with the contractual remedies. I say this because it's not uncommon for investors to enter into a commercial contract with, say, an agency or state-owned entity that has control over certain resources of the state. And of course, under the contract itself, there will be dispute resolution mechanisms. The point of note is that even if an investor were to bring a claim based on its contractual rights, they would not be prevented from also bringing a claim under the AKIA because the AKIA provides a separate set of protections in international law. Fourth, the arbitration method depoliticizes the resolution of disputes by providing investors with a neutral international forum to deal with their disputes. And this is because if a foreign investor were to sue the host state in the host state's own courts, in many states, it would not be surprising if the host state's courts are reluctant to make adverse findings against the government. And for the investor, there would also be concerns about undue influence by the host state over its judiciary. So the AKIA allows the investor to choose a neutral international forum where the investor and host state can each appoint one of the decision makers on the panel that would hear their case. Fifth, treaty claims also exert political pressure on host states. Such claims are often quite high profile because they involve states being asked to pay millions of dollars to investors. Unsurprisingly, for most states, they would not welcome such publicity. So it's not uncommon for states to back down or settle the dispute before it actually goes to arbitration. And this is how investors may not even have to actually go through with the litigation to enjoy the benefits of AKIA. And finally, the resulting award from arbitration enjoys greater global enforceability. The AKIA provides for the possibility of arbitrating in a few different forums, but I want to draw particular attention to arbitration at what is called ICSID. That's the International Center for the Settlement of Investment Disputes. So if an investor gets an award from ICSID, then it will have access to a very powerful enforcement mechanism. And I'll elaborate on this in my next slide. So this map outlines the ASEAN states that have joined ICSID in red. In order to make use of ICSID's powerful enforcement mechanism, both the investor's home state and the host state have to be parties to the ICSID Convention. And this convention is a treaty that currently has 156 contracting states. The reason why I say ICSID is very powerful is this. First, if you collect an ICSID award against the host state, you can enforce the award against the host state's assets in 156 contracting states, which is extremely broad coverage. Second, the local courts of an ICSID contracting state are not allowed to examine or go behind the merits of the ICSID award. They basically have to enforce it as though it were a judgment of their own courts. Third, compliance with the ICSID awards is very high because ICSID is part of the World Bank, and non-compliance may trigger potential political and economic consequences at the World Bank. And now I want to highlight some practical considerations when a potential dispute arises. So the AKIA sets out various options for resolving disputes that arise under the treaty, including going to the host state's courts, going to ICSID arbitration, or arbitration in other centers. However, the AKIA has a fork in the road provision, which makes it clear that if you choose one method of dispute resolution, you shall not essentially resort to any of the other methods of dispute resolution. So this means that if the investor has chosen to bring a claim based on AKIA in the domestic courts of the host state, it will be barred from also bringing an ICSID arbitration on the same dispute. The underlying purpose is to prevent multiple proceedings happening in respect of the same dispute. And therefore, it's quite important to consult specialists at the outset of a dispute to avoid accidentally compromising the right to bring a treaty claim. Next, AKIA also provides for what is called a cooling off period, which must be satisfied before a claim can be brought. This essentially requires investors to try and resolve the dispute by engaging in consultations and negotiations with the state before they can even lodge the claim. Investors typically kickstart this process by sending what is called a trigger letter to inform the host state of its grievances and inviting the host state to the negotiating table. The cooling off period in AKIA is 6 months, which is very common. And I want to stress that this can be a very useful period to engage the host state and try to achieve an amicable resolution and de-escalate things. Last but not least, investors should also consider how they go about managing the risks and costs of a treaty claim. Bringing a treaty claim or litigation of any kind is, of course, a big undertaking from a business. The expenses associated with doing so are often a concern. And it's not uncommon for investors to find themselves in a situation where they struggle to afford the legal costs to begin with, precisely because of the illegal measures or actions taken by the host state that have impacted their investments. So I wanted to highlight 2 possible tools that can be used to manage the risks and costs of pursuing a claim. The first is third-party funding, and this can take several forms, but the most common arrangement is for a professional funder to fund the costs of the legal proceedings in exchange for a percentage of the award if the claim is successful. This helps investors to manage their own exposure in a claim and could also help to keep the litigation off the company's books. Examples of some third-party funders are actually set out on the slide here. And it's worth noting that many funders have established offices in the APAC region to meet the growing demand for such funding. I also want to touch on a common question, which is whether the investor will lose control of the entire case to the funder if they obtain funding. The answer is that it's not quite the case, that the funder will take control entirely. Rather, because the funders provide funding, when it comes to certain decision points, key decision points in the course of the dispute, such as settlement or withdrawal of a claim, the investor and its counsel would have to consult the funder. But ultimately, if the investor insists on, for instance, withdrawing or settling a claim against the funder's position, then they will likely be able to do so, except that they would have to reimburse the costs that have been incurred. So many of these arrangements will be highly bespoke, and it very much depends on what is agreed between the investor and the funder. And now I'm onto my last slide. This is the second tool that I wanted to talk about, which is the CFAs, or conditional fee agreements. And these are quite common in a number of jurisdictions, but only recently became legal in Singapore in May 2022. Essentially, CFAs are agreements where the lawyers are allowed to tie their legal fees to the outcome of proceedings. If the claim succeeds, the lawyer will be paid a success fee on top of the legal fees, but if the claim fails, then the fees will be reduced or waived. An example would be something like the lawyers will charge 70 to 80% of the actual legal fees incurred if the claim fails, but they will recoup an additional 20% of the legal fees if the claim succeeds. And this is another way to manage the risks and costs of an arbitration. If you have any questions, I'll be happy to answer them later on. Thank you. And now I hand this over to Francis.
Hi, good morning. Well, I'm just going to, after the very helpful presentations by Eric and Hong Chuan, I'm just going to talk about, I don't have slides. I was looking at the papers until last night. Now, I just want to talk about some of the considerations that you will come across. Hong Chuan has touched on some of them when a claim arises. But let me go into some obstacles that can come up, things that you need to think about when you actually want to proceed to make a claim, right? So the first point I want to say is, and this has been flagged by Hong Chuan, which is when something goes wrong, when you have invested in an ASEAN member state, typically you already have a contract. There would be a contractual framework with someone in that country, right? It may be a private entity, or it may be a entity owned, controlled, or with the government of the member state having a stake in that state agency, right? Your contracting party. So the first thing that you need to bear in mind is that you will have contractual remedies under that contract, right? And you just need to bear in mind, Hong Chuan has spoken about arbitration, that when you do invest in a member state, you should provide for neutral dispute resolution, preferably, and all of you, if not most of you, will be familiar with arbitration. So you should put in an arbitration clause. Alternatively, you would bear in mind when you enter into that contract, when you invest in an ASEAN member state, that you also have the option of having your dispute resolved in the before the Singapore International Commercial Court, which was formed in January 2015. That would be a very good option for you to consider, right? So I would recommend that you consider, and there are many pros and cons. So you should, I'm not going to go into it. This is not a talk on the pros and cons of SICC dispute resolution as compared to international arbitration, but that's an option that you really need to consider at the time you enter into the contract. So first point, you would have contractual remedies, number one, right? The second point is that you would have a parallel remedy, again, something that Hong Chuan has flagged, under the ACIA, right? So you have a business-to-business remedy, and then you have a business-to-state remedy under the ACIA. Now, again, the constituent requirements of a breach by the member state, that has been covered by both Eric and Hong Chuan. Now, and Hong Chuan has also flagged the limitation period, right? Which you need to bear in mind, 3 years from the time you knew or you could reasonably have known of your claim. Now, let me talk a little bit about this parallel remedy in terms of the fork in the road provision, right? That was mentioned earlier. So you have the option, if you are take out a parallel remedy against the member state, so not against your contracting party, which could also be the member state, but you want to take out an action against the member state under ACIA, right? So you have an option, firstly, of the domestic courts, which or tribunals, which most of us will know that may not be the best solution. Now, then the second option is under the ICSID rules, right? So and it has also been flagged, as you know, that Laos, Myanmar, Thailand, and Vietnam are not parties to the Washington Convention, which gave rise to ICSID, right? So if there's a dispute, let's say a Laotian investor has invested in Thailand, right? Then this ICSID, either main rules or additional facility rules, will not be available for such an investor, because neither Laos or Thailand are parties to the Washington Convention, right? So ICSID arbitration would be available if either the member state, concerned, or the state of the investor are parties to ICSID. So in the case of a Laotian investor investing into Myanmar, neither of them would be. So ICSID arbitration would not be an option. So just bear that in mind. The third option is UNCITRAL rules, right? Now, this is a useful tool, because one of the things that you need to bear in mind is when you choose an arbitration under UNCITRAL rules, the April 2014 UNCITRAL transparency rules would come into effect, right? And those rules, unless the two parties agree that the rules will not apply, right? The transparency rules don't apply. So if you have a potential claim under ACIA and you choose to proceed with UNCITRAL rules arbitration, then the UNCITRAL transparency rules kick in, and your arbitration will be fairly open. The claim, details of the claim, your pleadings, your papers, your submissions, your hearings will be made public, right? And the reason I say this is an important consideration, because in our experience, many ASEAN member states would rather that the content of the arbitration be kept confidential, which is one of the great advantages of arbitration. But if the transparency rules kick in, then effectively you're having a public hearing, right? And ASEAN member states generally do not like that, because there is a huge risk, especially when elections are around the corner or elections are happening, for these disputes to be politicized in their countries, right? Many of you will be aware what I'm talking about in some of the neighboring countries where such disputes are politicized at elections. So if you opt for UNCITRAL arbitration, one of the things you need to bear in mind is that the member state in particular may have a greater incentive to resolve the matter before it gets onto a full-blown arbitration. The last option, again, would be arbitration under ASEAN Regional Arbitration Center or any other center by agreement. So both parties could agree, the member state concerned and the investor concerned could agree to an arbitration, say, under the Stockholm arbitration rules, right? So those are the fork in the road provision. Now, if you start this parallel remedy, the one last point I want to make is, as has been mentioned by Eric, you need to watch out for the reservation list, right? So in Singapore, and there's been examples of that in Singapore, pig farming is covered under the reservation list. So, if you're a foreign investor, you can't really have a claim. So in Vietnam, licensing requirements in respect of book publishing, of firecracker manufacturing are all covered by reservations, right? So you've got to make sure that you are not covered by reservations made by the respective member states before you invest. Now, the third point I want to make is that even for an investor member state dispute, party autonomy would apply. And even though the ACIA provisions do not mention, for instance, SICC, dispute resolution, my sense is that if both parties agree, it would still be possible, right, to go to the SICC. Now, I say this because there are a whole series of considerations as to whether you want, say, arbitration or a dispute resolution process like the SICC dispute resolution process, because many criticisms have been made of classic arbitration procedures. For example, in treaty, one of the big challenges that treaty arbitrators face, or treaty provision end users face, is that there is no system of precedent. So if you look at the ACIA and the fair and equitable treatment formula, that formula has been construed in other treaties, right? In many different ways by different treaty arbitral panels, right? Because, you know, you have an ad hoc arbitral tribunal deciding on whether your case comes within the treaty provision. And so different arbitral tribunals, differently composed, come to different views. And none of them are bound by the other, right? So that's, and there have been other criticism of arbitration, the fact that it's become costly. People are not, 50% of end users are not comfortable with arbitrator performance. So parties may wish to consider other options like Singapore International Commercial Court dispute resolution, right? With access to, you know, some of the top jurists in the world. So bear that in mind. Now, one of the big bugbears of SICC as opposed to arbitration, of course, is that the question is, can SICC awards be enforced as well as arbitral awards under the 1958 New York Convention? And the interesting thing to note is that all ASEAN member states are parties to the 1958 New York Convention on enforcement of arbitral awards, right? But SICC awards are increasingly, if you look at it from the ASEAN context, Malaysia, Brunei, Myanmar, because of the memorandum of guidance entered into with Myanmar and Singapore in April last year, there should be no problem. But if you're dealing with a country like Vietnam, again, it's a civil law country where there is a very good chance that a court judgment of the SICC will be enforced in Vietnam, right? But those are things that you need to think about, you know, when you get to what you really want to do, right? Fourth point, Hong Chuan touched on consultation, right? So there's a cooling off period of 180 days. You've got a written notice. The Article 31 does not provide for the form of consultation on negotiation. Our recommendation would be to adopt a formal process of ADR, mediation, for this purpose, right? Bear in mind that you're dealing with a state, right? And state, it's very difficult to have an informal negotiation with a state, because, you know, there'll be a multidisciplinary task, multi-ministerial task force of the state that will be involved on the other side. So it is always helpful to go through a formal process like mediation under the auspices of the SIMC, for instance. So the advantage of that is also that formal documentation would need to be filed, such as the points of claim and points of defense, at least an outline. And so the investor would be better appraised of the state's position in the event that the mediation is not successful, right? Next point, many times you may have to exhaust domestic remedies. First of all, you have a contractual remedy, right? As I've outlined. And you may have certain remedies with respect to investments, investment-related losses in that particular member state. And if you don't exhaust the domestic remedies, the state might make the argument that, you know, you should have done that first before you take on the ACIA route, right? The only thing that you need to bear in mind there is that you need to pay close attention to the 3-year limit, right? But you need to factor that in. Is there a domestic remedy that you need to exhaust, right? 6th point, if you do take an action within the member state, either because you want to be seen to be exhausting domestic remedies, or because you are pursuing a contractual remedy against your contractual counterparty in the member state, then bear in mind that if for whatever reason you do not get a fair hearing or you are discriminated against in that judicial process in that member state, that fact itself will give you a right to bring a claim under the ACIA for having been subjected to discriminatory measures or not being fairly and equitably treated, right? So just bear in mind that the conduct of any domestic proceedings in a member state that you carry out, and if you are stymied because there's been a lengthy delay, or you've got a judgment which is not being enforced in that country, or your claims are not properly allowed to be aired, then you will have a claim in all likelihood, on the basis that you were not given proper access to judicial right, I mean your legal rights by the judiciary of that country, right? Which is in a broad sense an organ of the state, of the member state as well, right? Now, the next point I want to make is just touch on, just so that you're aware of what sort of claims have been brought. Well, we've not found any, I haven't found anything under the ACIA, although there are potential claims brewing. But the ACIA had predecessor treaties, the 1987 ASEAN Investment Agreement, for instance. And under those predecessor treaties, we've had some cases. So let me just give you a couple of examples. Hong Chuan has touched on one, the 2000 case of Yongchi, which is a Singapore investor and the Myanmar state. In 2004, 4 years later, there was another case between a Singapore investor and Indonesia, where the Singapore investor had a minority stake in an Indonesian state-owned cement company. That matter was settled, right? And then in 2011, you had a Thai company who took the Lao PDR to an arbitration under the UNCITRAL rules, right? The arbitration was seated in Kuala Lumpur, and there was an award for US 57 million, but then there was an application by the Lao PDR to set aside the award in the Malaysian courts, and they succeeded, right? Those are the only examples that we found of private investor disputes with a member state prior to this. No surprise that a number of claims we are aware are brewing in respect of the cancelled high-speed rail project, which was due to be completed in 2026. But I think they are holding back the claims because there is some hope that if the previous regime in Malaysia comes into power, the project may be reinstated. But those are some examples. Now, I just want to make, let me just do a time check. Fine, looks fine. I'm just going to make two more points. The next point is this. In our experience, when we have investors having issues with the conduct of member states and thinking of potential claims against member states under the ACIA, one challenge we found on the ground is that sometimes the investor, when he invests in these ASEAN member states, has not kept his hands clean, right? So for instance, in Malaysia, you have, as Eric has again explained, certain sectors of the economy, you need, for instance, many of you will be aware, minimum Bumiputra involvement, right? And so sometimes arrangements of convenience are entered into by these investors into Malaysia, where they come to an arrangement with certain Bumiputra individuals, but the understanding is always that those Bumiputra individuals will not be holding the stake for themselves, right? And what we found is, and there are other examples of trying to circumvent restrictions in some of the ASEAN member states in Laos, Vietnam, and Myanmar, and so on. But when a dispute arises, then you are stuck in a catch-22 situation, because the other party then has the ammunition to say the court or the arbitral tribunal should not grant any remedy in this case to that investor, because they have their hands are soiled by some form of illegality when the investment was done, right? So it's proven to be problematic, and many times the parties will really withdraw because the risk of adverse publicity and the claim being not upheld because of this, it's tainted by this illegality or unlawful arrangement is very, very great, right? So that's something you need to watch out for. Keep your noses clean. The last point I want to make, in terms of the number of, you need to keep a keen finger on the pulse of a number of these points when this arises. The last point I want to make is that you have the ACIA, which is the umbrella multilateral treaty that you can look to when you need a remedy against a member state. But bear in mind that there are a large number of bilateral investment treaties between intra-ASEAN, between members of ASEAN. Take Singapore, right? So Singapore, is party as all, other ASEAN members of the ACIA, but they also have BITs. Now, again, it would be with Cambodia, Indonesia, Laos, Vietnam, right? As example. So Singapore has BITs with these countries, right? So a Singapore investor who is invested, say, in one of these countries, Vietnam, if a problem arises, you have a choice. Apart from going through the ACIA provisions, you have a choice of going through the provisions of the bilateral investment treaty between just Singapore and Vietnam, right? And so this is an area that most people leave out when they are considering an action. So just bear in mind that Singapore investor who has invested in Vietnam now has the option of going through the ACIA or the BIT or both, right? And so under the ACIA, you heard all about these reservations. Those reservations may not apply to the BIT. The wording, the protection, the ambit of duties of this host state in the BIT is very different from the ACIA. Go look at it yourself. I don't have time to go into this. So it's not impossible, though it will not be good, for someone to take out two actions, one under the ACIA and one under bilateral investment treaty, because the content of the duties are different. You might lose one, but not lose the other one, right? And if there are parallel proceedings, it's not clear how the arbitral tribunals under each treaty are going to deal with it, because the treaties themselves do not have clauses to prevent multiple fora being employed. The principles of lis alibi patents, forum non-convenience, and so on, a stay of the action, are not covered by any of these treaties. So it's going to be a fairly big challenge. And this is something that I think the ASEAN member states need to look at in order to rationalize the treaty platform, right? You're having parallel multilateral treaties and bilateral investment treaties, which are still, a lot of the bilateral investment treaties, if not all of them, the review I looked at last night, most of them, if not all of them, predate the ACIA, right? Which was signed, as Eric has said, in 2009, came into force in 29 March 2012, I believe, right? But you have that problem, right? You also have a different form of treaty shopping. Now, Hong Chen spoke about a form of treaty shopping. A different type of forum shopping would be then, the Singapore investor can sit back, in his office in Singapore and figure out whether he wants to go, whether he wants to opt for the ACIA claim or the BIT claim. So that's also a form of treaty shopping, which I think it's the interest of ASEAN members not to engender, right? And if you look at a trading bloc, the EU, for instance, in Europe, the EU decries intra-EU BITs for some of the reasons that I've outlined, right? So thank you. Those would be the points that I wanted to make today. Thank you.
Thank you, Francis, for your presentation. We would now like to actually launch the polls for the webinars before we actually move on to the Q&A. So we have launched the poll on your screen now, so you may take your time to answer it. So yeah, we will now like to invite all the speakers and Mr. Jason Lee for the moderated Q&A session.
Thank you very much, Rahini, and to our speakers, Eric, Hong Chuan, and Francis. Perhaps I can begin with Eric. So I guess some of businesses are wondering how they can check what the non-conforming measures are for each ASEAN member state, and any pointers you may have on making sure they are looking under the correct sector or the correct section.
Thanks, Jason. That's a good question. So actually, all the FTA text as well as the schedules of non-conforming measures can be found on the Enterprise Singapore's FTA portal. So if you just do a simple Google search on Enterprise Singapore FTA, you should, if I recall correctly, the first link that you click on should bring you to the Enterprise Singapore FTA portal, and that should have all the FTA text, including the schedules of reservations of the parties to the FTA. In terms of how to make sure that you're looking at the right measures for the schedules of reservations, I guess, as mentioned earlier, what you have to look at is to really scrutinize all of the entries to make sure that the sector of interest to you is not within any of the exceptions that's listed in the schedules of reservations. Sometimes the schedules of reservations have a very broad kind of like all sectors covered. So this law and regulation in this ASEAN member state applies generally to all foreign investments across all sectors. So you need to make sure that the exceptions that you're concerned about, the law or regulation you're concerned about, does not fall under this, both the general broad-based kind of reservations as well as the specific sector that you're interested in. Yeah.
Thanks a lot, Eric. And a second question for you as well. I think many of us are aware, I guess, publicly or in the news that Indonesia has been imposing different domestic content requirements across different products or sectors, like energy, mobile phones, pharmaceutical products. What is your understanding on whether these are consistent with AKIA, and what companies or investors potentially impacted can you do about this?
Thanks, Jason. Yeah, that's a good question. So if you look at the current AKIA text before the fourth protocol, the prohibition of performance requirements obligation is actually only limited to that of the TRIMS level kind of commitments, and that doesn't include domestic content requirement. But if you look at the fourth protocol, after the entry into force of the fourth protocol, then yes, there is this domestic content requirement prohibitions for each ASEAN member state. But the problem is the fourth protocol has not actually entered into force yet, because only 9 ASEAN member states have ratified the fourth protocol so far. So this domestic content requirement may not have entered into force. And as such, I think it's safe to say that Indonesia's regulations in this regard is likely to be consistent with the ACIA, at least until the entry into force of the fourth protocol. Now, if you ask, what about the other FTAs that Singapore have with the Indonesia, such as the most recently entered into force Regional Comprehensive Economic Partnership Agreement? Yes, the RCEP actually have active prohibition of performance requirements obligations, which includes prohibitions against domestic content requirements, like the kinds that you mentioned. But I think if you were to scrutinize on Indonesia's schedules of reservations, you realize that it actually has carved out against the kind of regulations that they have currently, whether it's the Omnibus law or whether it is one of the more older kind of investment laws that they have. So unfortunately, this is one of those issues that we have been in negotiations with our counterparts for a very long time. Sometimes this involves issues of sovereignty, and it includes the national interests of the countries involved. So there are like limits to how much we can negotiate with our counterparts with regards to the entries that they have in their schedules of reservations. But we do appreciate any feedback that the participants to this webinar has. We'll take this feedback into consideration when we do our negotiations with our counterparts in our upcoming review of the AKIA as well as the RCEP. I'm actually pleased to inform the participants here that the ASEAN members are actually currently in discussions to have a 5th protocol to amend the AKIA. So maybe during this 5th protocol to amend the AKIA, there can be some discussions that we can have on the measures of concerns that participants have with regards to some of the laws and regulations they've encountered during their investments into the region. Yeah. Thank you.
Thanks a lot, Eric. It's very insightful on how businesses should find out whether their sectors or their products investments are being covered greatly. And yeah, definitely echo your view that we are happy to work with MTI to gather views from businesses on what are the issues and barriers they face in markets around ASEAN. So maybe I move on to Hong Chuan now. Hong Chuan, would you be able to share a bit more about how company could potentially begin the arbitration process that you mentioned, what are the forums and process of agreeing on arbitration panel that can give confidence, I guess, to both state and investor on their neutrality?
Yeah, certainly. Thanks very much, Jason. So on the first question of how one would begin the arbitration process. So let's say you finished off with the cooling off period and you've realized that you still have a claim on your hands and things have not sort of fundamentally changed, then you would have to issue a notice of dispute to the state in question. There's a 90-day waiting period. So this is to put the state on notice that a claim is going to be commenced against them. And then subsequently, as to how to begin the arbitral process, that depends on the forum that you choose to have the arbitration take place in. So the ACIA itself provides for quite a number of different forums in which you could take your case to, including ICSID, including going to the host state's own domestic courts, including using the answer trial rules, which actually many of the different arbitral institutions are qualified to administer. But I would say what's most commonly used for investment claims would be to have the matter heard in ICSID, or for it to be administered by the Permanent Court of Arbitration, what is called PCA, under the answer trial rules. So the process of beginning the arbitration process, it will very much depend on what forum is chosen, but generally speaking, say for instance, under ICSID, one would prepare what is called a request for arbitration, essentially setting out all the different facts that give rise to the claim and all the different legal supporting documents to your claim as well. And as for the process of agreeing on the panel that might give confidence to their neutrality, actually what's inside the ACIA is certain requirements for the arbitrator who is appointed in these proceedings. And that can be found at Article 35. So what happens is by default, one arbitrator will be chosen by each party. And then the third arbitrator shall be appointed by the agreement of the disputing parties. So essentially, parties have to try and agree. And as for their own party nominated candidate, they do kind of have a choice. And the overriding requirement that's set out in ACIA is that the person who's appointed as an arbitrator must have expertise or experience in public international law, international trade, or international investment rules. So that's the very basic requirement that there must be. And in addition, essentially they must be independent and also able to conduct themselves fairly on that basis. And so what happens is if, for instance, say a party discovers that the arbitrator has some kind of connection to the other party, there will be processes in place to provide for the removal of such arbitrators as well.
All right, thanks Hong Chuan for the very comprehensive response and very enlightening. I think I also have another question from the audience about how whether their company or entity would be considered as being in a member state and therefore entitled to the protections under ACIA. So for instance, an entity with significant operations here in Singapore, but controlled by an entity in a non-member state, maybe for illustration, maybe a regional HQ based in Singapore, but having the global HQ in USA, which then subsequently makes an investment in Thailand. Would this, investor or investing entity be called ACIA protections? And would the, status of this entity in Singapore, say, being a joint venture, how would that affect whether this investor is eligible for ACIA protection?
Sure. So, for instance, an SG company with substantive business operations in Singapore that's controlled by a US corporation, right? As you say, it would still be protected under the treaty. So what I had discussed earlier on the denial of benefits provision is where this company just incorporates in Singapore but doesn't have substantive business operations in Singapore and is controlled by a non-member, an entity that's from a non-member state. So all these requirements taken together, if all of these are satisfied, then that particular investor would be denied protections under the treaty. So then if we were to change that one factor where, say, that particular company, even though it's controlled by a foreign parent company, it has substantive business operations, then it'll fall within the protections of the treaty. And that, I must say, is, and the ownership, the concept of ownership or control is quite separate from where the HQ is. So actually the treaty itself provides for certain definitions of what's considered ownership or control by the parent entity. And that doesn't necessarily have a connection with, say, where the regional HQ or where the parent HQ is. And as for the status of a company as a joint venture, that doesn't really affect anything. And I say that because the question will always be, what's the nationality of this joint venture as well? So if, for instance, the nationality of a joint venture, because oftentimes joint ventures, I mean, we talk about them in business terms as joint ventures, but in essence, most of the time they are set up as a company and they always are incorporated somewhere. So the question would also be, well, where is this particular joint venture actually incorporated? Does it fall under the requirements of an investor under the treaty?
Right. Thanks a lot, Hong Chuan, for clarifying that. And I was personally wondering a follow-up question on that. You mentioned that there's a clear definition with regard to which I guess some of these definitions. But what about significant business operations? Does the agreement clearly state what would be considered not having significant business operations and what would be considered?
Yeah, that's a great question. So actually, unfortunately, the agreement doesn't define this particular term of what's called substantive business operations, but based on essentially cases that have come before tribunals and how this particular phrase or similar phrases have been interpreted by tribunals, essentially they'll take into account several factors. And the idea is not that, okay, this has to be a large scale business, right? But rather that it must have something that's more than just a shell presence where, you know, it's just incorporated in Singapore, for instance, but doesn't have a bank account, doesn't hire anyone. But on the flip side, right, say for instance, you have a company that's incorporated in Singapore and they hire maybe 2 permanent staff and, you know, potentially have a bank account, then that's much more likely to qualify as substantive business operations.
Right. I guess in essence, the spirit is to prevent treaty shopping, people setting up an entity just to get access to certain protections. Right?
Yes, that's right. It's to prevent people from just being a Singapore company in name or, you know, a Philippines company in name, for example.
Right. Thanks very much, Hong Chuan. So I think I've got one last question from the audience, and maybe Francis, if he doesn't mind, could potentially answer this question from Asia Excel, who's saying that Philippines regulations have investment requirements of, I think, minimum capital, investment capital of 2.5 million USD. Would that be something that would be addressed by ACIA, or given that I guess domestic companies in Philippines itself wouldn't need to meet these requirements?
Well, you know, that's quite an interesting question, but I guess the answer to that will depend on someone trawling through the framework, right? The legislative framework, which I think has been very helpfully outlined by Eric and Hong Chuan, right? Which is, what is the state of the law in Philippines? One needs to form a view whether that is discriminatory of the foreign investor. And if it is, then the question is whether some form of reservation or non-conforming reservation applies to this particular indicia, right, of investment in the Philippines. Now, if none of it, and you know, then it applies in the sense that there's no reservation, and really, if one looks at the framework of the ACIA, the conclusion is that this is in fact a discriminatory measure, then of course one will have rights under the ACIA. But I think before you get to that point, you know, Jason, one would, you know, unremarkably have to do your homework, you know, and I think that may not be a straightforward task, but, you know, it has to be done in the way that, you know, the speaker before me had outlined, right? Thank you. Not very helpful.
Right, thanks. Right, thanks a lot, Francis. But you're right. I think maybe we need a better platform to actually examine some of these specific use cases. I think I have another question from the audience, and perhaps I think Hong Chuan may want to take this because it's regarding the denial of benefits. And the question is, who bear the burdens of proof for this? Would it be the host state to raise and prove, or will it for the claimant to actually show in the first instance that they don't fall under any of the categories within the denial of benefits?
Thanks very much, Jason. So I would say as a matter of practice, usually the denial of benefits clause would be raised by a state. So for instance, when the state gets a claim, in essence, one of the objections it might raise is that, look, you're an investor that falls outside of the protection of my treaty. So in that instance, it would be for the state to basically raise all of the relevant supporting evidence that backs up this particular assertion. And usually as an investor, when you yourself set out, say in a request for arbitration, some of the details, it's normal that investors would set out their incorporation information as well. So in order to show that they qualify within the treaty, but I don't think it extends to the extent that they have to show that they don't fall within the denial of benefits clause. So I would say in practice, pretty much the state will be the one trying to prove this point.
Right. Thanks a lot, Hong Chuan. I think, and thank you to all speakers for answering many questions from our audience and from us as well. I don't see any further questions from the audience at this point. But if any of you have any more questions, please feel free to email us, and we will be happy to convey them to our speakers and get a response to you directly as well. So I think I'll pass now the time back to Rahini.
Thank you, Jason, for that. So thank you everyone for your attendance today. We also like to take this opportunity to thank the speakers for their time and presentations today. So we have come to the end of the webinar. Please also assist us to submit the end of webinar poll if you have not yet to. Yeah, thank you everyone.
Thank you, guys. Have a good rest of the week.
Thanks, everyone.
Thank you.
Thank you.
Goodbye.
Bye.